This is Precision Property Management et al. V Community House on Broadway.
Good morning, Your Honor. Jesse Conway for the defendants.
Okay.
And Justin Lee for the plaintiffs.
Okay. And are you both ready to proceed today?
Yes.
In Your Honor, if I may briefly, I've
Please.
just been retained. My clients had a heck of a time finding an attorney on this. I have sent my notice of appearance off. I just have the complaint summons, I believe the amended complaint, and then the court's preliminary injunction with a hearing set for today. So that's what we have. I spoke with counsel this morning. I understand there may be a motion for contempt. I don't have records that my clients were served with that. Maybe counsel can speak to that. So I don't think we're ready for that one, but I don't have all the facts on the service.
Yeah, that's fine. We have not served them. I don't actually know whether the order has been signed off ex parte or not. But we're ready to move forward simply on the injunction matter today.
Okay.
To the extent, sorry.
Yep, nope, I was just gonna say, I had it noted for both show cause and contempt, but I didn't actually have the show cause contempt motion. But I did have the order for preliminary injunction that's set to today, that specific issue.
Yeah, that's correct, Your Honor. We have not served the show cause order, and frankly, had we done so yesterday, I don't know if it would have been timely.
Okay.
Not to argue against myself, but the basis of that was simply that we felt, in our opinion, that this court's May 19th injunction was being violated by the defendants.
Okay.
And that's relevant to today's conversation about the injunction.
Understood. Okay. So I guess, Mr. Conway, I am glad that you're here. I hadn't seen your notice of appearance yet. So as far as it relates just to the preliminary injunction, you're okay proceeding today?
Yes and no, Your Honor. I mean, I can go into my arguments on that. I guess if the court had questions or more documents, I think I would ask for leave to set over, but I think ours is more of a legal argument, which if the court, and I didn't file any response to this, so I'm just here making it, orally. So I think we can get some work done. I may ask for a set over if the court has factual questions they want support for, but I think as far as the legal arguments, I would like to have a decision today, and I can explain why when we get into the argument.
Okay. I'm kind of on the fence about, I don't know, Mr. Lee, obviously I don't want to make anyone go through trial by surprise. I don't know if you know already what Mr. Conway is going to say.
No, I mean, we talked earlier. I said, I assume, you're going to oppose this, right? We didn't get into the substance. I guess if we're going to continue this, I would ask that the preliminary temporary injunction stay in place until we come back in front of you, Your Honor.
Well, yeah, Mr. Conway, go ahead. It sounds like
if I could just make argument, Your Honor, and it's pretty brief. It's nothing too novel, but I looked at the pleadings, and my client's a homeless shelter, and they have 50 children, and they bought a brand new built a playground for them, and we get this order, and it's sitting there, and they can't play on it. And the complaint, as I said, read it, says, hey, you built this thing, and since we house individuals that can't be within playgrounds, they had to move, which I understand they already moved. I'm not aware of any law that says my clients can't build a playground. I'm not aware of any sort of it doesn't need permits. There's no county, there's no zoning issues. I'm not aware, there's no covenants on the land or restrictions. We don't have any contracts with the Department of Corrections. They don't have any jurisdiction over us to say we can't build this. So I'm not aware of any legal basis whatsoever that would say that we cannot have a playground for homeless kids. There's been an amended complaint. There's been allegations of a spite structure. There's been no discovery on that. I understand that I'm not asking that that be dismissed. I'm just thinking that during this proceeding, if they want to prove that, my clients did this somehow to, out of spite, fine, but I don't see that there's really any benefit to, chaining off this playground while we litigate. And so, when the court looks at, okay, is there a clear equitable right? I don't see that. Are there any injuries? This Precision can house other people. They don't have to house people that cannot be by the playground. And I understand those people have already moved. So when we look at, balancing the equity and moving forward, I don't see any benefit to anyone from, chaining this thing off while we litigate. And I just don't see that there's any sort of reasonable legal basis whatsoever to do so. So we're asking that it be immediately lifted, and if we need to litigate, we can continue litigating.
Okay. Mr. Lee, why don't I hear from you? And I guess if I need further briefing or have questions, we can figure out how to go from there. But let's get started and see where we end up. Go ahead.
My beginning standpoint is that the court found there was a basis to at least restrain the operation temporarily. And on the element of whether irreparable harm would be done, well, the harm is already commenced and is real and visceral. Over a quarter of the residents have been forced to be displaced from here. And there is a strong legal basis set forth in the causes of action in our lawsuit. Is we contend that the defendant did this not only intentionally to interfere with my client's business, but with malice to force these residents away because they didn't want them nearby around the corner from this homeless shelter or from the residents' children. And so because the harm has already been done, I mean, at this point, it can't be undone. That the DOC simply will not place residents where this playground is affixed to the ground as a permanent playground.
So let me just ask you this. So just if I assume is true that it has impacted the number of people that can be placed with your client from DOC, is that a financial impact?
It's incredibly large financial impact. I mean,
so then if you win, you could be made whole through a monetary judgment, right? I mean, what I'm getting at is usually injunctions are meant to address things that can't be addressed through a monetary judgment.
I understand what you're saying. Right. I guess I would concede there is an adequate remedy at law after adjudication on the merits.
Are there other harms beyond that monetary impact to your client?
Well, and I will agree or concede I don't have standing necessarily to make this argument, but the people that have been displaced from housing now, who interestingly enough, may be close to be rendered homeless, they're suffering irreparable harm. Now, again, yes, we're not bringing claims on their behalf.
Right. And this playground is wholly on defendant's property, right? It's not encroaching or on your client's property, right?
Right.
Okay.
And my understanding from talking with my client and his interactions with DOC is that there can be play structures, there can be playing. The fact that it's affixed to the ground and permanent is what triggers the issue with DOC.
Okay.
That it's a permanent structure at this point.
Well, anything else you want me to know on the injunction issue?
Justin?
Yeah, I think maybe my client would like to add something, and I'm fine with that.
We could take leave, but Your Honor, I just want to speak to the damage. First of all,
Well, I'm gonna hold tight real quick.
okay.
I don't know if what he's about to say is filed in a declaration. I certainly don't want to take testimony that's not under penalty of perjury and filed with the court already. So typically,
I think it is. It's just that I think, excuse me, I just think we're missing what's happening right now that I put in my declaration.
All right, then let me swear you in. So go ahead and raise your right hand. Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead and state your full name, please.
David Tackey,
And go ahead and spell your last.
Tacke.
Okay, Mr. Lee, or is it Lay or Lee? I apologize.
Oh, I pronounce it Lee.
Lee, okay, thank you. Mr. Lee, if you want to ask your client some questions, it sounds like he may want to give some information to the court.
Sure, Mr. Tackey. What other damages have taken place that I have not addressed to the court that you would like to share?
Well, first of all, no, they all have not moved. Yes, we've already sustained damage because some were forced to move. If the playground continues, the rest of them have to move. Right now, they are in suspend because we did get a temporary injunction. So several are waiting for that. If today's hearing does not continue it, then we have to tell them that it's playground again and that's never been there. And after 15 years, you've got to move and they can't stay there. So that's ongoing of people's ability to reside there. And second, it's not easy to just turn it over because we've operated that for 30 years. You can't just put another renter in when there's a group of sex offenders in with that housing. That's what it's been for 30 years. So this is ongoing and it's going to get much larger and much more severe if this isn't continued today.
And Mr. Tackey, what is your understanding of where do these residents go and what sort of support do they have for next steps?
Most of a lot of them will be homeless right now. Most of them can't find places, and it's chaos. I just spoke with some this morning, some people from the DOC on a few of them that are waiting for this outcome. But it's not easy. We've been one of the sole places to go for them for 30 years.
Okay,
I have no further questions.
okay. Mr. Conway, did you want to ask any questions?
No, I just have a brief rebuttal whenever the court's
Okay.
ready.
Okay, thank you, sir, for your testimony. Mr. Conway, go ahead.
Yes, I guess if we start, and again, briefly, there has to be a clear legal equitable right, and there's no statute that's saying if you live across from a place like this, you're barred from putting in a playground. So there's no legal equitable right. There's a theory that this was somehow done by malice, and respectfully to counsel, I think that shocks the conscience a bit. Again, we have a homeless shelter with 50 kids that are excited about this playground. There's no malice here. They can litigate that. So I think that should be at the forefront. There's all this talk about damages, but again, you got to establish liability. You got to establish a legal right, which there's just none. As far as the damages, I think the court is correct that if there comes out to be some email where there's some sinister purpose of this, there's some malice, you can recover monetary damages, and that's all that defendants have. They make arguments of the people living there, but they're not parties to this. So the defendants, the only damages they could foreseeably have is some sort of monetary damage. I understand that the people that left have been almost immediately replaced, so I don't think there's going to be damages. But for today, if there's any sort of damages, the only possible damage they would have is monetary damages, and that you can award that later. You don't have to stop it. So if we're looking at balancing equities, we have something that you can't replace. The time of this litigation, the year or 2 years or however long it takes to get through the court system of the kids not playing, you never get that back. Money, you can get that back. So I think if the court balances and needs to make a call, I think I think the order has to be lifted because there's no legal basis for it. Thank you, Your Honor.
Anything further for the moving party?
Yeah, I mean, I think we do have a legal right. I mean, this is our second count is for tortious interference with my client's business expectation that has been going on for over 3 decades. And So I don't really agree with opposing counsel on that. But yeah, I would concede that there is potentially inadequate remedy at law down the line once there's adjudication on the merits. So I won't disingenuously argue against that.
Understood. And so I've read the briefing from plaintiff, and now that defense is represented, I've heard your argument. I appreciate both sides. I appreciate your testimony, sir, on the impact of this. The things I have to look at for a preliminary injunction, and I'm going to be very clear on the record. This is not a decision on the merits. This is a determination solely as to whether a preliminary injunction should be in place while this case plays out and while there's discovery. So obviously, I hear some allegations that this playground was put up in malice. I can't and won't today make a finding of whether that is true or accurate. I think the parties will have to litigate that in front of a trier of fact. But the very first question is, have plaintiffs demonstrated a clear legal or equitable right that's protected under Washington law? That's a tough one for me to find in favor of plaintiffs just solely based on the record in front of me. I understand that folks have a right to run a business. They have a right not to be interfered with in their business contracts. But has their right been infringed by someone building something on their own property that frankly anyone could build? So I can't find that there's a true demonstrated clear legal and equitable right. If there is, do I think plaintiffs have shown that they have fear of immediate invasion? Yes. Do I think that if they have that legal and equitable right, that they've shown some actual or threatened substantial injury? And for me, I believe it's primarily monetary in nature as it pertains to precision property. Yeah, but then I go back to the sum and substance of what TROs are for, and it really is to protect against things that the court can't compensate for. And in this case, if plaintiffs prevail, ultimately, they can be made whole by a monetary judgment for the loss of income that they have encountered because of loss of DOC residence. So I am going to deny the TRO. It is going to cease today, June 3rd at 2:55. It is lifted. If the parties, I certainly can do a simple bench order, but I assume the parties may want to present an order to me. I guess, Mr. Conway, I'll leave that to you for.
I'm fine with a bench order, Your Honor, if counsel is.
Yeah, I am too.
Okay, I'll do a bench order and get that filed. Mr. Conway, I would like to believe it'll be emailed to you since you aren't quite in our system yet. I don't know. So if you don't receive that in the next day or two, just reach out to court administration for a copy.
Thank you, Your Honor.
Okay, anything else the parties want to put on the record today?
No, Your Honor.
Just procedurally, I suppose that strikes out the show cause.
You know, I
Order.
didn't even have that in front of me if you have filed it recently, it hasn't been scanned in yet. So I wasn't going to address it today. If certainly, I'm not going to tell you you can't have a show cause or contempt heard, but I'll leave that up to you. It's not in front of me today on motion.
Okay, all right.
Okay.
Talk to my client. Thank you.
All right. Thank you all for your time.
Thank you, Your Honor.